Hi, what are you listening to?
Oh, I'm listening to a podcast on statelessness.
Oh, what's statelessness?
Statelessness is having no recognized identity to any country under the operation of law, where they are limited to accessibilities and benefits only citizens can have. Being stateless was described as a form of punishment, more primitive than torture, for it destroys for the individual the political existence that was centuries in the development by the U.S. Supreme Court decision in Trump and Dulles 356 U.S. 86 1958. I read about a case, Azimah Hamzah and Ketua Pengarah Jabatan Pendaftaran Negara and ORS, where appellant is the daughter of two Cambodian refugees who was born in Kuantan, Pahang, Malaysia. The parents were not Malaysian at the time of the appellant's birth, and after living in Malaysia since birth, appellant is naturalized as a Malaysian citizen and is permanent resident since birth. The appellant applied for Malaysian citizenship, where the application for Malaysian citizenship pursuant to Article 14(1)b, read together with Section 1E of Part 2 of the second schedule of the Federal Constitution, where Article 14(1)b of the Federal Constitution reads, subject to provisions of this part, the following persons are citizens by operation of law, that is to say, every person born on after Malaysian Day and having any qualifications specified in Part 2 of the second schedule. And Section 1E of Part 2 of the second schedule provides, subject to provisions of Part 2 of this Constitution, the following persons born on or after Malaysia Day are citizens by operation of law, that is to say, every person born within the Federation who is not born a citizen of any country otherwise than by virtue of this paragraph was rejected. The appellant applied to quash or reject as invalid the decision made by the High Court by order of certiorari, which is the court process for judicial review of a lower court's decision from a higher court. Appellant also seek order for mandamus to grant the citizenship, directing first respondent to issue MyCard or certificate of confirmation of Malaysian citizenship that recognize the appellant as a citizen by operation of Act 14(1)b of Federal Constitution. High Court have found that both parents were Cambodian nationals at appellant's time of birth, and appellant failed to show that she was not a citizen of any country at the time of birth. Therefore, the High Court dismissed the judicial review. The decision of court appeal is that this appellant met the first requirement, Article 14(1)b of the Federal Constitution. By virtue of the principle of just sanguinis, where citizenship is determined by his or her parents, the second requirement, Section 1E, is not met, as she is not stateless at the time of birth, but in fact is a Cambodian, due to her parents still being Cambodians at the time of her birth.
Why do you think statelessness exists here in Malaysia?
The existence of statelessness can also be due to forced displacement, where refugees flee from their countries to seek heaven for them and their family from another country. However, in the case of Azimah binti Hamzah and Ketua Pengarah Jabatan Pendaftaran Negara and others, she was denied citizenship, and her appeal to the High Court was also dismissed due to failure to provide proof of not being a citizen of any country. This results in forced displacement of the appellant and leaving her stateless here in Malaysia. The lack of understanding of the law also contributes to the increase of statelessness, and referring back to the case of Azimah binti Hamzah and Ketua Pengarah Jabatan Pendaftaran Negara and others, the appellant was not aware of the possibility of being granted the citizenship of Cambodia, as she was born in Malaysia, though was born when both her parents were still Cambodian. Under the principle of jus sanguinis, she would have been able to gain citizenship from Cambodia instead of Malaysia, thus being denied a Malaysian citizenship. People of the public in Malaysia has expressed their understanding of statelessness as homeless, where these people do not have identity and is not under the protection of any country. They believe that statelessness is due to financial hardships, government issues that result to denouncing their own nationality. People who are stateless in Malaysia are people who has chosen Malaysia as one of their options to seek asylum away from their country. I actually have a friend that knows about statelessness as well. She's right over there. Hi, are you the friend that knows about statelessness?
I guess so, yeah.
What is statelessness?
Statelessness is a state of person, a citizen that does not actually have citizenship of any country.
How do you know so much?
I'm actually currently looking at a case, CTUV and others, and Ketua Pengarah Pendaftaran Negara Malaysia. It's about kid of Filipino descent where his mom is Filipino and his dad is Malaysian, but when giving birth, they were not married. So 5 months after, they registered their marriage, and when he actually registered for his citizenship, they denied it, and he went to court of appeal to appeal the case and the decisions against him. So what happened is that they were saying that under Article 15 and Article 14, he should be qualified as a proper citizen because of the fact that his parents are registered as married. But issue being, when he was given birth to or when he was born, they were still out of wedlock. So it ends up being like this whole phenomena where what does illegitimate consist of and what does illegitimacy actually means in terms of timelines, etc., etc. One thing about it is the definition of the term father when it comes to the Citizenship Act, whether the father just means a person who was involved in a person's birth or whether it's meaning the person who is married and then further on fathering a child. The court held that the word father in Article 14 and the federal constitution was then being said to mean that like the father has to be married. So it should be a person who is married and of a family in order for them to be considered an actual father, or else the kid would still be considered illegitimate. And under the Legitimacy Act, they did mention that a child that was born anytime prior to the marriage being registered would be considered illegitimate. It's very unfortunate because the two other siblings that came after that was registered as citizenship right after this CTB came.
Why do you think statelessness exists in Malaysia?
So within Article 14, 1B, it did state that anyone who is born within the federal after Merdeka Day should be granted citizenship, but this does not apply to every single cases out there. There are a lot of cases where this happens, but citizenship applications will be rejected for no absolute reason. One thing about it is because I am also experiencing this, so I feel like this case hits home to me. There's no really reason that they would reject your application except for just like minuscule reasons, and it is very interesting to see. I feel like there's a lot of things that consist of it. According to Christopher Spelt from University of Melbourne, he's a senior researcher. He did say that a lot of things can come from colonial descent, discriminatory policies, whether it's of race or gender. But specifically in Malaysia, we can talk about the fact that the Muslim law affects people that is Muslim, obviously. And so if you are a Muslim father, you can father a child without knowing the mom's descent or without being legally married to the mom. But that would violate like another law within the family law area. But civil laws and citizenship law that are affecting of everyone except for people of the Muslim communities would then state that this would not be viable for males of non-Muslim descent, and it only works for females who are giving birth to illegitimate child. So it's a very unfair gender discrimination. And one thing about it too is that the education within Malaysia and the stereotype that comes to the kid that are quote unquote illegitimate. The word illegitimate is used in such a derogatory content, and it is used to kind of put this stereotype that says that oh, they would be uneducated, they are a bad child, and punishments basically. And you can see the lack of citizenship and statelessness being as punishment for kids who are illegitimate just because their parents' decisions. With Miss Melina's interview that I recently had done, she did state that one of the big things is that we need to educate Malaysians about the form of statelessness and citizenship and how parents not registering as birth should not be a punishable thing. Part of the reason why statelessness happens is about administration differences. So to gain citizenship in Malaysia, not only do you have to apply for the citizenship, you also have to wait until the minister calls you in, gives you a literacy test, a language test, and the minister would handpick people that he would want to give citizenship to. Citizenship here in Malaysia is looked upon as a privilege, not a right that a person should have. Oh, I know another person who knows statelessness very well as well. Oh, you can just go over there.
Hi, are you the friend that knows about statelessness?
Yes, you're right.
Can you tell me more about statelessness?
Yeah, I will give you a 5-minute talk on why the statelessness exists in Malaysia. So as a base, I will talk about the case of OXT and pendaftaran besar kelahiran dan kematian in Malaysia. I use this case as a base and as an example on why the statelessness exists in Malaysia. So the case of OXT and pendaftaran besar kelahiran and kematian in Malaysia was recently brought to the Federal Court of Malaysia. This case states that a Malaysian father and a Chinese mother who was not a Malaysian citizen had a child in Malaysia. The birth of the child was not registered and no country granted this child a citizenship. In the case of OXT pendaftaran besar kelahiran dan kematian in Malaysia, that addresses statelessness and the claim of Malaysian citizenship according to the Malaysian law. The plaintiff, a 5-year-old girl born to a Malaysian father and a Chinese mother, like I mentioned before, asked the court to declare that the child was a Malaysian citizen by operation of law. This case illustrates the significance of citizenship and the potential consequences of being a stateless child. The Federal Constitution and the Births and Deaths Registration Act of 1957 and the National Registration Regulation of 1990 all apply to statelessness in Malaysia. The Births and the Deaths Registration Act of 1957 requires the registration of births and funerals, which is required in order to obtain a birth certificate and citizenship. The National Registration and Regulations of 1990 outlines the procedure of a birth registration and a birth certificate issuance. Malaysia's citizenship statutes are contained within the Federal Constitution and the National Registration Act of 1959. Mainly, the Article 14(1)(b) of the Federal Constitution states that the person born in Malaysia after Malaysian Day to a Malaysian father or a Malaysian mother is a natural citizen of Malaysia. Section 1A of the Part 2 of the Second Schedule of Federal Constitution specifies that by operation of law, a person born in Malaysia to a Malaysian father after Malaysian Day is entitled to a Malaysian citizenship by operation of law. And Section 1E of Part 2 of the Second Schedule of Federal Constitution grants citizenship to a person born in Malaysia who is not citizen of any other country. In keeping with the Section 17 of Part 3 of the Second Schedule of the Federal Constitution, however, a child born out of wedlock to a non-Malaysian mother and a Malaysian father must assume the nationality of the mother. This provision has generated controversy and criticism because it discriminates against the right to citizenship of children conceived outside of marriage. So the Malaysian government argued that in the case of OXT, that the plaintiff was required to acquire her mother's nationality under Part 3 of the Second Schedule of the Federal Constitution because she was born outside of wedlock. As the plaintiff was born to a Chinese mother and a Malaysian father and not to a non-Malaysian father and a Malaysian mother, the High Court ruled that the Part 3 of the Second Schedule of Federal Constitution did not apply to the case of OXT. The court determined that because of the plaintiff was stateless, child that was stateless, she was entitled to Malaysian citizenship under Part 2 of the Second Schedule of the Federal Constitution. The court determined that the plaintiff had not inherited her mother's nationality and was not a citizen of any other country. So the child that was born, which is stateless, did not have any passport or identification of any other country. So she was really stateless. The court also ignored the argument that the plaintiff's prior application for citizenship by registration under Article 15A of the Constitution prevented her from submitting the present application. Malaysia's legal foundation itself for birth and death registration is established by the National Registration Act of 1959. According to Section 13 of the National Registration Act of 1959, the parents must register the birth of the children within 14 days. Failure to do so may result in the child being stateless itself and the loss of citizenship. The OXC case demonstrates the importance of the birth registration and its huge possible consequences of failing to register the child's birth in time. with the limit of 14 days that is presented by the National Registration Act. It also highlights the current laws that are governing the citizenship of Malaysia needs to be reformed, particularly regarding the eligibility of children born outside of marriage. Because in the current time and societies, a lot of stateless kids are starting from children outside of marriage. So in conclusion, statelessness is a significant and a huge problem in Malaysia, and efforts to address the issue must be comprehensive and directed to its root causes. Even though progress has been made, much work remains to ensure that all Malaysians can exercise their nationality rights. By cooperating and adopting the basic and international human rights, we can guarantee that nobody in Malaysia will become stateless, not only in Malaysia but anywhere else. I have a friend who is nearby here you can talk to. She has a similar case to mine.
Hi, do you know anything about statelessness?
Yes, I'm actually doing a research on it right now. So, statelessness is a person who does not have a nationality or a citizenship. They do not get any protection from the state that they reside in because they do not belong to any country. Currently, I'm reading a case from 2018, Madhuvita Janjara Agustin and Augustin Lords Ami and others, where this child, she was born to a Malaysian father and a mother from Papua New Guinea. In her case, she went to the High Court to declare her Malaysian citizenship under the Section 14, whilst also looking into the second schedule of the Federal Constitution, into saying that she is eligible to get Malaysian citizenship because her father is Malaysian. But in her case, due to her being born when both of her parents were not married yet, in a way that she was seen as an illegitimate child. But under the Legitimacy Act of 1961, Section 4, it is believed that subsequently, as the parents do get married, she is not considered an illegitimate child as of anymore. So she went to court with her mother in behalf, who is suing for her. And in this case itself, it says that she had also brought in other evidence to show that her father is Malaysian, who has a Malaysian citizenship, where she did DNA tests to show that her mother and her father are both linked to her in support to get her declaration of this Malaysian citizenship. However, though, in the High Court, they had dismissed her case and they went to the Court of Appeal to appeal her case, and the judges had anonymously agreed that she should be given her Malaysian citizenship because they had looked into the Article 14 from the second schedule, Part A, where she should be able to have her Malaysian citizenship granted because she was born with a Malaysian father, and at the age of 11 when this case was being done, she was considered a minor and she did not have any citizenship or any documentation from Papua New Guinea as well. So in the Court of Appeal, as the judges anonymously took her case, they believe that she should be given her rights to citizenship, as they took this in a purposive approach. In a purposive approach is when the judges take the literal interpretation in an act in a more flexible way. And due to this, she was very fortunate in this case, as she was able to get her declaration of Malaysian citizenship. And in most cases as well, using the Article 14 and Article 15 itself, have made a few cases of those who are in the state of statelessness to actually get their citizenship in Malaysia. But again, it does not apply, and it does not apply, and it's not accessible to all stateless children. But in her case, due to how in the Court of Appeal the judges were using this purposive approach of Article 14, she was able to win her case.
Why do you think statelessness exists in Malaysia?
I believe that statelessness exists in Malaysia due to the fact that there are children here who are born from illegal migrants, those migrants who are also actually have already been stateless before. The fact that there has also been a lack or an absence of birth documentation. As soon as the children are born, some parents have this sense of ignorance that they do not wish to register their child to their registrar in their jurisdiction or state, or they don't feel that there's an importance to it. They don't put it as something that should be done. And also the fact that some of these children were born to parents that do not have valid marriage certificates. And due to these several reasons, a child may be in the risk of statelessness here in Malaysia. I also do have a friend who is on the phone. I'll just be bringing it.
Good afternoon and good evening to you, depending on what time you're watching this video. My name is Statelessness and I will be talking about statelessness. Now one might wonder, what is statelessness? Here is a simple definition of statelessness. In international law, a stateless person is someone who is not considered as a national by any state under the operation of its laws. So to simply put it, statelessness refers to people or a person who do not belong to any country by law. Now after that definition, you might ask yourself, are refugees considered to be stateless? And the answer to that question is, not all refugees are considered to be stateless, but some refugees are. Some stateless people have never even crossed an international border. Now I'm going to share a case with you called Manisha Sudhya Abdul Majid versus Katau Panjara and Oz and another. Forgive me for my mispronunciation of these names. This case is one of the 90+ cases that have been brought to courts in Malaysia. I'm going to read for you a summary of this case. Manisha's father was Indian and her mother was a confirmed Malaysian citizen. They were married under the laws of India on the 10th of June 1996. Subsequently, they registered their marriage in Malaysia on 27th December 2005 at the Kalim Religious Department. In 2016, Manisha had submitted application for citizenship by registration under Article 15(2) of the Federal Constitution of Malaysia, which states that the federal government may cause any person under the age of 21 years or whose parents is or was a Malaysian to be registered as a citizen upon application made to the federal government by his parents or guardian. Her application was unfortunately rejected. Manisha then filled an originating summons for declarations that A, by virtue of her mother's citizenship, she was a Malaysian citizen by operation of law under Article 14(1)(b), read with secondary schedule, Part 2, Section 1B of the Federal Constitution of Malaysia, which is discriminatory and is against the spirit of Article 8 of the Federal Constitution of Malaysia that prohibits discrimination on the grounds of gender. Manisha also argued that the word father in Section 1B should be interpreted as mother or either one of the parents. In Appeal 531, the second to the seventh respondents were Malaysian mothers that applied for citizenships for their foreign-born illegitimate children under Article 15(2) of the Federal Constitution of Malaysia. Without any success, the respondents sought essentially the same relief as Manisha, held by majority, allowing the respondents' appeal 531 and dismissing Manisha's appeal 273. One of the majority statements made by Kamuluddin MD was that the word father in Section 1B of Part 2 of the secondary schedule referred to the father only, and that the court could not insert or interpret new words into Section 1B to be read as mother or to include mother. In conclusion to this case, Manisha could not acquire Malaysian citizenship for the fact that her mother was a Malaysian citizen and not her father, and also that she was born in India and not Malaysia. This then leaves Manisha stateless. It has been addressed that mothers should be given the same right of passing down citizenship to their children just as fathers do in order to reduce and stop statelessness. Thank you very much for watching.